The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Welcome to RapidVisa Live, now streaming on YouTube and Facebook, live from our new studio in Las Vegas, Nevada, where it's 10 a.m. Pacific time. We are once again going to offer our $100 credit towards RapidVisa service. We'll select the winner randomly from the comment section. No actual comment necessary. Just put your name and say you want to be entered if that's what you want to do. And if you do want to leave a question, please give us as much detail as you can. Especially the country we're dealing with and any other details that are pertinent to your situation. That'll help us give you a more thorough answer. We do get a lot of answers that are not quite complete enough for us to give a thorough response. With me today is Pam. Pam is the manager of our assembly group. Those are the folks who assemble petitions here and in our Las Vegas office. So with that, I'll pass it over to Pam.
Thanks, Ben. We will start up with some news. DS-160 now requires your social media profiles. The online form DS-160, which is used for all non-immigrant applicants, including K-1 visas, now has a new questions about your social media. The question says, quote, select from the list below each social media platform you have used within the last 5 years. In the space next to that platform's name, enter the username or handle you have used on that platform. Now, the question mentions not to enter your password. Because of this, it is not likely an officer will see private content initially. However, CBP agents have been known to have you pull out your email or social media accounts on your phones and hand it over to them for review during entry to the U.S. The significance of this social media question cannot be understated. Not only will they be looking for the obvious terrorists or drug smugglers, but they are likely to also use your social media content to discover inconsistencies with your story and to catch you in a lie. For example, if you have an Instagram photos announcing how you're moving to the USA to marry your girlfriend, but you're applying for a B-1B visa and pretending to come on a vacation, this can be used to not only block you, but ban you. As we always warn people, be cautious of what you're posting to social media. If you don't want it to be seen by an immigration officer, it's best to keep it off social media. It's also important not to withhold any social media profiles from the DS-160, as any lie that you're caught in can and will be used against you.
The live stream will begin.
If you have an Instagram account, but you lie on the DS-160 and they find an Instagram account on your phone when you enter the border, that would be you being caught in a lie, and you can be turned away and banned from future entry. So it's not worth it.
Right, and as always, what we say is you need to be completely open and honest, but as with many other things like applying for a job and so on, social media is well known now as a way to check out somebody, check on somebody. So, we all need to be very careful about what we're putting there and make sure it's an accurate, reflection of what we are and what we want everybody to see. Okay, and then just a reminder, we're not attorneys. RapidVisa is licensed, registered, bonded, document preparer in the state of Nevada. Any information we give you certainly should not be considered legal advice because we are not qualified to give legal advice. We're just going to give you our best answer based on processing over 45,000 of these types of visas, and so you take that for what it's worth. Okay, let's jump right in. The first one from YouTube, we have Tucker T says, hello, the MVC says, you just need the most recent transcripts or you need the last 3 years transcripts. Okay, so I assume you're talking about tax transcripts. because you never need college transcript. So tax transcript or a copy of your tax return, either will work. A transcript is more official because that comes from the IRS, and that is better evidence. But strictly speaking, a copy of your return can work too. Okay, so you're required to give the last year, and then the forms basically say you can provide up to 3. So we always recommend up to 3, and in fact we have found sometimes if you do only provide the last one, they may turn around and ask for it anyway. So our advice is always give them 3 of the last 3 years of tax transcripts. If you haven't worked or you had no income during one or all of some portion of the last 3 years, then you need to indicate that to preclude them from just asking you. For instance, if you worked last year but not the year before, so you only give them last year's return, they may then send you an RFE and say, hey, we want to see the previous year. So to preclude that from happening, if you don't have 3 solid years of income evidence, explain that, and maybe you can save yourself an RFE.
Okay, next question is from Hassan Ali Ashraf. After my interview, embassy put me in administrative process, and after 4 months waiting, my spouse visa case has been returned to NVC. What could be next? My wife's economy is strong and she's a citizen. So your case has been put into administrative process. So administrative process means that your case has been forwarded to a higher authority, like for instance a manager or a supervisor, who will again review your case. And this usually happens when they find that you have insufficient evidence. Administrative process also involves requesting, or like RFE letter, request for evidence, which they ask you to provide more evidence to prove your case. And this will usually last for about 2 months or more, depending on your situation or your visa too. It depends on your visa and the situation you're into. But he says here, visa has been returned to NVC. Should it be USCIS?
Yeah, his case has been returned to the NVC. Yeah, usually they say, that's probably what he means. Usually they return
to the US.
Yeah, usually the NVC or the State Department returns them to the CIS if they're not happy with it for whatever reason.
Yeah, but after that, if you're able to prove your, to submit sufficient evidence, they will eventually approve your case, and then you will probably get your visa soon.
Okay, from Facebook, Mary is asking, Mary's on a K1, I guess. Can I apply for travel documents just for a quick visit to Canada? I live 10 minutes away from Canada. I'm afraid I'll drive the wrong highway and end up in Canada. The travel form wants a special date for a vacation, for example. Okay, if you're truly on a K1 still and you've not applied for the adjustment of status, let's discuss that situation. You don't want to leave the country when you're on a K1. It's a single entry visa. It does not allow you to re-enter once you leave the country. Second, you really can't accidentally go into Canada because you're going to come to an inspection station with the Canadian immigration folks. And if you end up there, it's okay. Just tell them, hey, sorry, I made a wrong turn, and they will surely let you turn around and come back to the United States. So I wouldn't worry about accidentally ending up in Canada. I think there are a few obscure places where there may not be any border, but if you cross one of those, just go back and you won't be checked. Bottom line is you need to avoid leaving the country when you're on a K1. Can you apply for a travel document? Technically you could, but it's only good for the duration of your stay, which is only 90 days. So by the time you get it, it would probably be expired already. So while you technically could apply for a travel, what they call advanced parole, it's unlikely you would get it in time to be of any use to you. What you need to do, and you're going to have to do anyway, is apply for your adjustment status. And when you do, you can concurrently apply for an employment authorization and travel document, and there's no additional cost, additional filing fee when you file that concurrent with your adjustment status. And then when you receive that, you could travel. But I would stay away from Canada. You know, you're not supposed to leave the country, or let me say, you can leave the country if you want, but your K-1 is a single entry visa. If you leave, you're not getting back without a travel document, and it's not realistic you're going to get a advanced parole travel document while you're on a K-1. So you need to file that adjustment status, wait to get that, what they call a combo card, which combines your employment authorization and your advanced parole, and then you can go back and forth Canada, you know, all you want while you wait for your actual permanent resident card or green card.
Okay, next question is from Voltaire Chavez. What is the CFO Seminar Philippines and why is it now required? The CFO Seminar, it is a requirement for Filipinos. That is it is just like a 1 hour seminar. I actually undergone this because I'm from the Philippines. I'm an immigrant myself. This is their way of like counting those who Filipinos who live permanently outside of the country. So they're like tracking Filipinos abroad. And why is it required? I guess because
it's a government that's thing. Philippines. It's not a requirement in the United States. It's a requirement the Philippine government imposes upon their citizens if they want to leave the country. So the U.S. government has nothing to do with it. They have the reasons. One of the other reasons, besides them trying to keep up with people coming and going, I suppose, is that they do, part of that CFO seminar is they will talk a little bit about abuse and your rights and dialing 911 and whatever. You know, they want to, everybody's concerned about things like human trafficking and slave trafficking, people being made unrealistic promises of a job or something, and then leaving the country and finding out that wasn't the plan. And so they try to warn you about some of that stuff, and it's not new. It's been 15 years at least, maybe much longer. The CFO seminar. So there's always been a requirement. You could do it in Manila or Cebu, but there's no leaving without it. What'll happen is in the Philippines, like most countries, excepting the United States for some odd reason, you actually have to go through Philippine immigration to leave the country. For example, you leave the United States, you don't go through immigration, you just walk out. So when you leave, before you can leave the airport, you have to go through Philippines immigration, and if they do not see your CFO seminar certificate in there, stamp in there, then they will not let you leave. And that's happened to people. They get to the airport with their ticket and their plane's leaving in 2 hours and they get turned away. And there's nothing you can do but reschedule your flight and go get it. So you have to do it. As annoying as it is, you have no choice. It's, again, nothing to do with the U.S. government. It's a Philippine government required. Oh, okay, so that was Pam. So mine is Facebook. Hatham says, hello, my relationship is going south with my spouse. Can I get a divorce without affecting my status, although I have a 751 pending? Okay, so you have removal condition pending. Yes, you can always get a divorce anytime you want. So your question is, how does it affect your status? If you've already filed the removal of conditions, honestly, it's not really going to affect anything. It'd be rare that you would get an interview for that. If you did, of course, you would have to be honest if that topic came up and say that we're separated or whatever. But really, if you've already filed your removal of conditions and now in the interim you start processing a divorce, which doesn't happen immediately. If you're just now thinking about it, it's going to be months before your divorce. You may well have your regular green card, your 10-year green card, before you even get to the end of a divorce process. So it sounds like you don't have anything to worry about. Again, you're always going to be honest. If it did come up and perhaps you had an interview, you would mention it, but you're almost certainly not going to have an interview. Most people don't. But let's go back to the case where what happens if I divorced even before I filed my removal of conditions. Yes, the people, that's not uncommon. We've done many of those. Sometimes relationships don't work, and your challenge there is it is possible to file a 751 without the person who originally sponsored you. You just have to demonstrate that the marriage was entered into in good faith. This wasn't, a scam to get an immigration benefit, but for whatever reason, it just didn't work out. And as long as you can show that and convince them that they go through. And they generally do go through in those circumstances. So either way, sounds like you're going to be fine, especially if you've already filed it, as you said. You really don't have anything to worry about. Just sit back and wait for that green card. Now, if your address changes and you don't receive the green card, you do have to worry about things like that. And you make sure your address is current. You change it with CIS if you have in fact moved from whatever address you put on the 751. Because if it's not deliverable and it gets returned, now you got another process to deal with. But bottom line is you should be fine. And even if it's asked and you answer, of course, honestly, that yes, we're divorcing or divorced, that still doesn't preclude you from getting your 10-year green card. We always had to say permanent green card because there's no such thing. They all expire in 10 years. So you should be fine.
Okay, next question is from Facebook, from Tony Alves, Tony Franco. Just passed my citizenship. I want to apply for my parents in the Philippines. What are some documents that I needed to prepare for my parents, or the steps to start for petitioning them? Okay, past citizenship, you probably have already taken your oath and received your certificate of naturalization. That's one vital document because you have to prove your citizenship when you file for a immediate relative such as your parents. And aside from that, you should be able to provide to the your birth certificate, which should list the names of your parents there. And we actually offer this service. You can check out our website, rapidvisa.com, if you want more information.
Yeah, and just to mention the form, you did say form. You're going to need a form I-130, so you can get that at uscis.gov, I-130, and then it has some detailed instructions to read through that. We'll be happy to help you with that. It's called an IR-5, but if you're going to undertake that on your own, you need the I-130. That's where you start. Read through instructions. It will let you know what else you need depending on your circumstance. And you do need to be 21 years old to sponsor a parent. So if you're not quite 21, you'll have to wait until you are. Okay, from YouTube, Stephen asks, I get frequent background checks for work, including FBI, NSA, CIA, and other government agencies. I've never been denied passes for work. Could this help or hinder? Well, if you already have a file with the FBI, if you already have a clearance, it probably helps. We see this a lot with military people. They'll go through just a little quicker. Does it? It helps. Yes. The bottom line is, sure. If you've been cleared to work for these agencies, then you're certainly going to have no trouble getting cleared to, request I guess you don't say what petition you're filing, but you're requesting a benefit for a spouse or fiance or parent or something. If you've been routinely checked, then you certainly have nothing to worry about. You should go right through. And in fact, the background check is one of the things that in the past has caused some delay in processing. So it may speed things up that you already have a record and you've been through this several times. However, lately in the last year or so, we've seen delays caused just more by the backlog and the intense scrutiny at the CIS as opposed to the background checks. So how much difference it would make today, I don't know, but certainly at least you have that peace of mind in knowing that you've passed these before, you're going to be fine.
Okay, next question is from Rachel Wright. Hello, I had my visa spouse interview and I got refused due to a 4 months overstay. Okay, I'm now eligible to file a 601 waiver. Do you have any recommendations for the hardship letter and evidence? Unfortunately, we don't assist with 601 waiver. We are not
Yeah,
attorneys.
that's right. It's not something we do. That's something that you need an attorney. If you want assistance, you can certainly try to do it on your own. I'd look on the internet, maybe get some assistance. But what they're looking for, generally speaking, and again, we're not attorneys, but what they're looking for is for you to show that your inability or denial of your ability to stay in the United States would result in a hardship, not for you, they don't care about you, unfortunately, result in a hardship for a U.S. citizen. And typically where we see this and where people are generally successful is when there's a child. So for example, you come here without inspection, or for whatever reason you're here without inspection, meaning illegally, you weren't inspected at a port of entry. and you have a child, and that child's a citizen, and you make the case that if I get deported, it's going to create a hardship on a U.S. citizen, which is this child, right? That seems like the most frequent. Again, we don't do them, but just from what we know about it, that seems like the most frequent case where these things get approved. If it's just you, there's nobody else in the picture, then you got a much tougher road, because again, generally to be successful with the waiver of inadmissibility is what you're looking for. You need to show that your inability to stay here or your removal would result in a hardship to a U.S. citizen. Again, generally, and we're just telling you what we know about it. We don't do these, we're not experts at it. Just want to tell you what little we do know about it. However, the latest statistic I've seen, which has been a few years back now probably, but was that the approval rate's pretty high, as much as 80%. And so it's certainly, I wouldn't be discouraged from trying it, but you are going to need to, I mean, my advice, if you can swing it financially, my advice is to find an attorney that specializes in that and see if you can get it, at the very least a consultation to get started down the right path, because it's a long process and you hate to file it and wait and have it denied just because you didn't write it up correctly. Okay, on YouTube, Pearl asks, "Hi, we've instructed RapidVisa to do our case. I won the $100 prize. Does it go towards my fees?" Well, yes, yeah, absolutely. If you're one of our previous winners, yeah, absolutely. You just need to let the agent know. Just give us a call, let the agent know if they're unfamiliar with it or unsure or whatever. We should have put it in your account. Although sometimes people win that don't have an account yet. So anyway, talk to the agent when you answer. If they're unclear what you're talking about, just ask to speak to a supervisor or somebody, and we will certainly give you that credit off of our services. Absolutely.
Okay, next question is from Nelson McNulty. So when you get your fiancé from their country of origin over here under the K-1 visa status, how quick do you have to establish getting your fiancé health insurance? Okay, if you're admitted here as a K-1 visa, you can apply for Social Security. I think that's one requirement from an insurance company, but I think it would be better if you do adjustment of status first, and then get your green card, so you can be added to the health insurance.
There's no requirement at all to get health insurance, but health insurance is not, for better or worse, it's not a government service, so it's completely up to your health insurance provider, whoever that is. I would call them and ask, but at the very least, they're probably going to want you to be married and perhaps for your spouse to have a Social Security number. But yeah, it's really a question for your healthcare provider or your employer. If your healthcare comes through your employer, I would contact their representative, because it's nothing to do with the government. These health insurance companies make up their own rules sometimes as they go along, and they do whatever they want. So I would talk to them. From Facebook, we have Ben asks, "Hello, I'm 100% VA disability, so my income is non-taxable. Would I just have to write them a letter explaining what's going on?" Well, you need a statement. You'll have some kind of VA statement, either your award letter or whatever is the most recent statement information you've got from the VA showing your benefit amount. So that's what you'll need. Just writing a letter won't work. When it comes to income, you always need third-party documentation. They're never going to take your word for it. Even if you give them your tax return, which is your word because you filled it out, you have to provide the supporting documents like W-2s. So when it comes to income, they're never going to believe just your word for income. You got to have third-party documents. So you can get that from the VA. You probably already have it, but if you don't, check your account online, whatever you got to do, and get a letter from the VA stating what your benefits are, and that is certainly acceptable. If, of course, the amount is enough. If it meets, sometimes depending on your situation and your dependents you may already have and all those things, you're not getting a break from the eligibility requirement, is what I'm saying. So yes, you can use your VA disability income to meet the income requirement, but it still has to meet the requirement. Unfortunately, you don't get to say, "Hey, I'm disabled, so can I get a lower level?" So, no, you still have to meet the same income requirements as everybody else. But But if it meets that requirement, you're in good shape. Just get that letter and you'll be all set.
Next question is from Haja Naziwa Nancy Giala. Hi, what kind of documents when an American wanted to marry in the Philippines? Fortunately, I'm from Philippines, so for you to get married in the Philippines, you have to, the basic requirements is you should be of legal age, which is 18 years old, and you should be able to marry because we are a monogamous country. You should be able to prove that you're single and you don't have you're not married. And another also vital requirement is for you to have marriage license. So for that, if you're an American, you may need to go to the U.S. Embassy in Manila, because we only have one U.S. Embassy in the Philippines, and that is located in Manila. You may want to apply for capacity to marry, and you have to bring that to our local civil register depending on where you want your marriage celebrated. So if you want to celebrate it in Cebu, for instance, then you have to bring that to the local civil register of Cebu, and then there will be a waiting period. I think it's still 10 business days.
Yeah, 10 business days.
Yeah, because they have to post it, and then you have to wait for that, and after that they will give you a license, and you will just have to bring it to any authorized solemnizing officers, such as the judge or a head of the military, or you could also go to a church if you want a priest to solemnize your marriage. And after that, you have to make sure that your marriage certificate will be forwarded to the civil register, because if you don't do that, there would be more delays, because it's not automatic there. You have to follow it up, and make sure it's filed with the civil register, local civil register where you have your marriage, and because it will take about 1 month for the local civil register to actually forward it to the PSA, or Philippine Statistics Authority.
Yeah, we have a detailed article on our site. It's pretty involved, and you're going to need to allow at least 3 weeks that you, the U.S. citizen, can be in the Philippines because of the waiting period, and it's tough for a lot of people to do if they're working, take that much time off, and that's why the fiancé visa is more popular. Although we certainly do a lot of spousal visas, and we're happy to help you with that. I'm not trying to discourage you, but check out our site. We have a detailed instructions on marriage in the Philippines. It's worth doing if you can take the time off, but otherwise, if you're short on time, I wouldn't try it. Okay, next one. Casimir says, does it have to be complete documents when we are sending to RapidVisa? Yes, if you're using our service, we're gonna have a phone call with you, what we call a pre-mail checklist, and we're gonna go through the documents. We really don't even want you to mail us anything until you have all of it, because there's no point in piecemealing. You send a few documents at a time, whatever. That just makes it more difficult for everybody. So yes, you'll need everything, and what that consists of depends on your case. We wouldn't know that till we have your information. But yes, you will need everything before you mail it to us.
Okay, next question is from Villanueva Luke. What's the difference between the Form 130 and 130A from previous and latest form? They have the new form came out, and we'll fill out the new forms. It's basically the same. All the information they were asking on the last editions is the same. It's just the edition date, which you could find it at the bottom of the page. But make sure that you are filling out the latest edition, because if not, they will reject your whole petition. It's basically the same.
Right. They generally make those forms for 2 years and expiration in 2 years, and at the end of 2 years, they almost always just change the date and stop taking the old one, which seems silly because they rarely change the questions. But that is the case with the latest I-130. So while the previous one is really exactly the same other than the expiration, they will not take it. So you don't want to try that. Okay, from Facebook, Heather is asking, I have my own business, but deducted a lot last year due to the new addition to my business, so it looks like I didn't make enough money. But I've got a bank statement this year and I've made enough money. Will it be okay to be a co-sponsor? Okay, that's an extremely common question. You know, as a self-employed individual or a person who owns a business, you are going to try to take advantage of all the write-offs you can get to reduce your taxable income, right? Makes sense. You have every right to do it. Unfortunately, though, for CIS and tax purposes, your income is basically what you pay taxes on. Now, there's some oddball exceptions for people who have non-taxable income and various things. But in your circumstance, whatever you pay tax on is your income. So if you were effectively able to reduce your income down to a very low level or even zero, or it could even be negative, then you have no income and there's no change in those facts. So your options are to use assets or to amend your tax return to claim enough income to get you over the limit, you know, like change it so that you show $30,000 in tax in income. You have to pay tax on that, but that is a tactic that people have done, is gone back and amended their income tax even after they filed it. But no, it's not possible to say, hey, look, IRS, I actually made $100,000, but I had $80,000 in deductions, and this is why I only reported $20,000, but really I made good money. It won't work. Everybody's tried it. If you didn't pay tax on it, you're not going to be able to claim it. And that's the hard answer, but I'm going to save you a lot of heartache by trying to get around that. Everybody's tried it. People try it with lawyers. People try it with accountants. Bottom line is your income available to support the immigrants, what they're looking for. If you say you spend it on furniture, fixtures, whatever on your business, then it's not, in their view, it's not available to support the alien. You could have had $1 million in revenue. They don't care about your revenue at all. There's no point in even mentioning it. All that matters is your income at the end of the day, so that you're taking home and you're paying taxes on. So, unfortunately, income is one of the areas where there is no wiggle room. It's got to be exactly right, and they're not going to take your word for anything, unfortunately.
Okay, the next question is from Ryan Christensen. When I pay for the premium service with you guys, what are the services should I put my packet together and send it to you for review, or you guys will put it all together? And the biggest concern is that pictures, will you print them out and put them together, or should I do it myself and you guys will only review it? We will put everything together. We will arrange it, assemble it, put it in a folder with your name and your type of petitions you're applying and everything. But for photos, we highly encourage you to at least put them in a paper with a brief description, especially if you're filing K-1. That's very important because you have to prove to the immigration officer that you have met within the last 2 years. So if you don't have any description at all in your photo, that would be less convincing evidence.
Okay, from YouTube, MJ asks, how deep in our social media these border agents go? We share some very intimate moments. On some, nothing public, but platforms like Messenger. Well, they're not asking for your passwords, and so they're just going to see what is publicly visible. And so whatever is public, you should try to look at all your accounts yourself from when you're not logged in, or from, even to make sure you're not logged in, log out or use an incognito window or go to a computer you've never used and see what you can see without a password, because that's what they can see if they want to. Nothing says they're actually going to go look through these accounts. And my suspicion is in most cases they probably don't. But whenever there's a question or borderline, or the relationship is not been going on for very long or whatever, they're looking for additional information to confirm, to help them make a decision. So yeah, look through there and see. I mean, if it's private, like in a messenger, they would not have access to that. Now, they could get it with a court order or whatever, I suppose, but that's unlikely to going to happen. But either way, it never hurts to clean that up. I mean, I would resist the temptation to use social media as an archive of your life, because there's no guarantee that stuff will even be there. Any of these businesses could be gone tomorrow or decide to take all that down. So, I wouldn't use that as my archival for memory purposes anyway. And having said that, my best advice is go back through and clean up that old stuff. What value is having it there? as far as intimate messaging. Now your photos from the past, sure, leave that stuff there. If it's normal photos, nothing shady going on or whatever. But bottom line is, right now it appears, and this is new, so none of us are experts, it appears they're just going to see what any public person can see. My best advice would be make it all private and worry less about it, but still clean it up anyway, just in case.
Okay, next question is from M28. I broke up with my girlfriend 4 years ago. In retaliation, she filed an order of protection. I never challenged it, and it expired a year later. I am married now for the past 6 months and filing a CR1. Is this a problem? I have been cleared many times in FBI background checks for my job. I don't think that's a problem if you're filing for spousal visa. It will be a problem if you're filing for K1, because under the IMBRA, the International Marriage Broker, you have to disclose your previous convictions, protection order, and all this stuff. But since you're filing for CR1, they will only need, at least at the NBC stage, they will need the only documents, background checks, police certificates from the beneficiary, not from you. For your part, at least now they require you to submit your divorce decrees, and that's only it that we're seeing right now. But they keep changing their instruction. So, but whenever they ask you to provide a protection order, as long as you're able to provide the proper documents, I think you will be fine.
From YouTube, Abdullah asks, is it okay for the USCIS if we get married from the first time meeting? Well, the short answer is yes, it's okay, and it's actually quite common. So, I mean, usually the first meeting comes after a fairly long period of chatting and Skyping or whatever. But yeah, it's pretty common. So that's not going to disqualify you. Now, you know, the shorter the relationship is, the more evidence we suggest you provide, just to make a solid foundation to convince the adjudicator that is legitimate. But there's certainly nothing disqualifying or nothing unique about marrying on your first trip to the country.
Okay, next question is from RSS Villanueva Luke. In CR1, do I need to file for work authorization once I got my green card? Oh, no. If you once you get your green card, then you will be authorized to live and work legally in the United States. So that would be like your sort of license to live here legally, in the United States legally. But if you have not get your green card yet, then that may be the time you will apply for work authorization.
Okay, from Facebook, Clay is asking, I recently started a new job and I don't have any pay stubs yet to prove my income to apply for my spouse's income. What are my options? Okay, so you should have, and if not, you should get from your employer a job offer letter, something that states your income and states that it's a permanent job, it's not temporary. So if you didn't get something like that, usually you do, but if it's a smaller place, sometimes it's very informal. Somebody shakes your hand and says, start Monday. But, you know, just ask them for a letter on company letterhead that has your full name, and it says your pay rate is important. If it's hourly, then it needs to say you're a full-time employee. If it's an annual salary, then that's sufficient. But you can use that in lieu of your check stubs. But also let me say, you don't need these pay stubs when you initially file. I don't know that you say what you're filing for spousal. You won't need this until you get to the NVC stage. So by then surely you will have some pay stubs. Unless you're already at the NVC stage, then you're going to use that letter. But you're also going to need something for your past income, because they do want to know for the past year, and we recommend 3 years worth of proof of income. Okay,
next question is from José Natalia. After they received the AOS, or adjustment of status, we got RFE for my daughter. Just they need check again the affidavit of support. After we resent that, they did not send anything any information. Is it common? Yeah. So after you get an RFE, you probably got an RFE because of affidavit, right? I'm not sure.
Well,
the question is not very clear, but like I'm assuming you got an RFE because of the affidavit of support. So assuming you have complied the RFE, you're able to submit all the requirements as stated in the RFE. You will have to wait another maybe a couple of weeks or even a month for them to actually resolve your application. So yeah, that is quite common. If you don't hear from them after a month, then it's probably time to contact USCIS or schedule an InfoPass online.
Okay, from Facebook, Joshua asks, the recent closure of the American Embassy in Manila, does this affect, well, I can stop right there and say it's not been closed. On current approvals, they're waiting for National Visa Center email. Homeland Security seems delayed for us. Okay, the embassy has not closed. I've never heard that rumor. What they did close is some USCIS field offices, but that will not impact anything. The embassy is very much open. We have people interviewing today, and we had people interviewing yesterday there and tomorrow, and there's no, it's unlikely they would ever close that embassy. It's one of the bigger ones around. It's kind of a regional center. So that's not true. Wherever you heard it, it's wrong. You know, we can look out our window and see the embassy in Manila, and I can assure you it's open and people are coming and going. So they did close some USCIS. There are some USCIS processing centers outside the United States. The current administration closed those, so they've gone away, but that has nothing to do with your case, really. I mean, if you were doing if you're filing a direct consular filing, they call it, they just now send them back to the United States. So either way, it's not going to impact you, so I wouldn't worry about it. And it's just not true. The embassy is open.
Right. The next question is from Clay Smothers. My spouse received some of his medical result on a CD before arriving to the U.S. on a fiancé visa. When we apply for adjustment of status, do we send the original CD along with supporting documents or a copy of the CD, or should we print the contents of the CD? Okay, when you are when you're submitting your adjustment of status, you can actually go to a USCIS website. There's tips for filing there. The CD is not acceptable. They only accept documents or documentary evidence. So CD.
You know what I think he's, hold on a minute. You know what I think he's talking about is the
CD for medical exam.
CD that St. Louis gives you that has the lung.
They
used to give you the big X-ray film.
Yes.
And now they just give them the CD. So that's what he's talking about. But like Pam said, no, you won't send that in.
Yeah. What you need is the Form DS 3025, the medical examination report. If you were doing K-1 visa, but make sure that you file your adjustment of status within 1 year from the date of your medical examination, because after 1 year they would not honor that anymore, and then you will have to undergo again another medical examination, which will cost around $400. So yeah, just make sure you file your adjustment of status within 1 year.
Okay, from YouTube, Sweet Morn American says, is it okay if I don't have police clearance from Saudi Arabia? Okay, so you're required, you're asked to provide a police clearance from any place you lived and worked since age 16. So lived and worked, that doesn't mean vacation, but if you're in Saudi, you're probably working. And the exception is if there are some countries, and I don't know off the top of my head if Saudi's one of them, there are some countries that will not provide a police clearance if you've left the country. In other words, they won't send them outside the country, right? I don't know if Saudi's one of those, but if Saudi does not require it, then no, you can't provide it, obviously. If they do, then you absolutely have to have it, and it will hold up your whole process if you don't provide it. On the State Department website, they do list which countries will provide what documents, from birth certificates to police clearance and all criminal backgrounds, all those things. And so if Saudi Arabia will provide it, then you absolutely will have to have it. You'll not get away without it. If they absolutely do not provide them to people who've left the country, then you won't need it. And the State Department knows this because they have it on their site. So if they see that you can't get it, they won't even require it. If they see you can, they will, and any explanation you try to provide won't work. You'll have to have it. So hope that answers that question.
Okay, next question is from Dinelle Wendy. If your Filipina get her fiance's name tattooed on her, will she be disqualified to do the K1 or CR1 visas? And if your Filipina has been in rehabilitation drug use, can we still do the K1 or CR1 visas? I don't think the tattoo will disqualify you for applying any petition.
No, I never heard that one.
Yeah, I know it's not common in the Philippines. I'm from the Philippines. It's not common. We usually associate that like tattoos for ex-convicts, but it's actually popular here in the United States. So I don't think that will disqualify her. But yeah, the second question, rehabilitation drug use. Well, yeah, this may pose some problem, because if later on during the examination or medical exam she will came out positive, that will definitely become an issue.
Yeah, that's right. Drug use is one of the things that supposedly they look at during the medical exam. So if it's something in the past and there's been no recurrence, and the embassy is, the adjudicator is convinced of that, then it may not be a problem at all. But if they have any suspicions that this might be ongoing, or there's just recreational use of drugs, then yes, it could be a problem. We have seen it. We don't see it often, but we have seen denials for drug use. So that's something you'll have to work through. Unfortunately, you have to talk to a lawyer if you want a more legal opinion on it. But our experience is, yes, sometimes people have trouble with that. So it is something you need to take seriously and do your best to present that that it's in the past and she's clean.
Yeah.
Okay, from Facebook, Christy asked, can I use my salary as an affidavit of support for myself as I am keeping my job? What the CIS says is that if your income will continue from the same source, it can be used. But you're going to have to prove that. So for example, you're making your money online. I assume you're the alien because of the way you're asking it. So because you say you want to support yourself. So for example, you have a eBay business or something like that, or e-commerce business, and all of your income is coming from there, and nothing's changing when you move, then yeah, that would be an example of income that would continue. Or you have some kind of structured settlement or something. So yes, if the income will continue uninterrupted from the same source, you can use it. We don't see that very often, I got to tell you, because it's just not common. But yeah, if that's legit and you can prove it, then yes, that income is eligible to be considered.
Okay, next question is from Chris. My fiance and I have known each other for 18 years, so have a lot of evidence. Does that length of time help us, or does it matter? Please. If you're applying for a K1 visa, one of the requirement there, vital requirement actually, is to prove that your relationship is genuine. If you have been with the person for 18 years, of course it will help, but you have to prove it. You have to present evidence, documentary evidence such as photos, chat transcripts, and travels together. Anything that would help prove your relationship is genuine. So yeah, 18 years, that will help a lot.
Okay, and before I get to the next question, just a little update here. We had a previous caller mentioned something about Manilla office closing, and so our producer here looked that up, and it was exactly as I said. The CIS field office is closing, but that has nothing to do with you getting your visa. If you're doing direct consular filing, it just means instead of filing directly to the consulate, it's gonna get filed in the United States. But for the average person going to do an interview, no, it's completely irrelevant. I could definitely see how people get confused by that. But a USCIS field office, that is not the State Department. The State Department does your interview. The State Department grants your visa, not the USCIS. They're completely different departments. They all fall under Homeland Security, but they are separate. And so it's definitely confusing when you don't work in this field every day. But yeah, bottom line is, don't worry about it. They were never going to touch your visa anyway, and they had nothing to do with it all along, except in the rare case of direct consular filing, and even then it will just get transferred to the United States in process. Okay, so back to Facebook. Luke is asking, is it okay if I don't see my husband in 3.5 years, but we have constant communication every day for 3 days? Now he's filing for CR1. Well, it's okay if you're married and you've been married all this time. there's, with this fiance visa, there's a meeting required. You must have seen each other in the last 2 years in person, right? There's no such thing with the CR1. So technically, yes, it's absolutely fine. Realistically, you're going to have to go that extra mile to prove that this whole thing's legitimate. But if it is, and you've got evidence, like you say, that you've been communicating and circumstances, whatever they are, have kept you apart, you shouldn't have a problem. It's just, as always, when your case varies from the average case, then it's on your back to kind of go the little extra mile to show, hey, I know this looks weird, but here's the deal. Like, explain why. Why haven't you gone there in 3 years? Financial reasons or whatever, just have your documentation in order. But technically, according to the rules, it's absolutely fine. There's no rule that says you can't not see your spouse for 3 years and then do a CR1. So I think you'll be fine if everything's legit and the up and all that. Neither one of you in between has got married to somebody else and now you're getting back together. If there's no weird thing going on like that, then you should be fine.
Okay, next question is from Luis Lugardo. How long will it take after the interview in Manila, the visa approval, to obtain the passport with the visa and sealed documents? Well, at least in the Philippines, after your interview, if you pass the interview, you get approval, you get approved, you will usually receive your passport with the visa sticker on it, on your passport, usually within a week or two. But yeah, just make sure your address can be located, because I know in Philippines it's really hard to locate addresses there. Just make sure it's reliable. It could actually be located by the carrier, the mail carrier. So you will receive that within a week or two.
Okay, Hayana asked, are there other U.S. embassies in Philippines besides Manila and Cebu? What about Davao City? Okay, so the embassy in Manila is the only one where you can do visa interviews. There is a satellite office or field office in Cebu that's at the Waterfront Hotel, but it's really just for American services. Like if I'm an American, I'm there, I need to renew my passport or, get some kind of services from the U.S. government. It's not for, they don't do interviews there. It's not even open all the time. It's a part-time office. And they do occasionally kind of take their show on the road, and they'll go to places where they know there's a lot of expats, like Davao City, and have a session where they will let people come in to, the primary example is U.S. citizens whose passport's expiring and they want to renew it, or they need some kind of consular services. But the bottom line is, if you're trying to get a visa or do a visa, none of that helps you. You have to go to Manila.
Okay, next question is from YouTube. Sweet Morena American. Okay, we are in a relationship for about 4 years now, met already in person, preparing now for all documents to file for K1, but we are not yet engaged. Will there be a problem to that? Well, if you're filing for K1, you should be engaged. A fiancé, it means like you are actually engaged. You're intentionally planning to get married once the beneficiary arrives in the United States. So it's very important that you get engaged before you file your K1.
Right, because you're going to need to prepare a letter of intent saying that you intend to marry, which basically means you're engaged. Now, whether or not you have a big ceremony or something, or even a ring, that's up to you. But you do need to be engaged, otherwise it's just going to look a little odd. So there you go. Okay, PJ is asking, I haven't worked since February 9th due to an injury, but I have my 2016-2018 Irish transcripts. I more than meet the guidelines. I applied for EDD and just got approved for food stamps. Will that be an issue? Okay, well, yeah, your current income is important. And your past income is important too. It's one of these tough things, but yeah, you got to think about their concern. What they want is, they don't want immigrants coming here and then not being able to support themselves, so they end up on public benefits. So that's what they're trying to accomplish here, is to make sure that if you're bringing somebody here, they're not going to get here and get on benefits. If you yourself are on public benefits, yes, you are not going to qualify. Doesn't matter how much you made last year. Now, if you've got assets, because you've been making good money for a while, if you've got assets you can use, and you're going to return to work soon, and so on, that's one thing. If you're on disability, you can use that income, because disability is an earned an earned benefit. It's not public assistance. But if you're on public assistance, that income cannot be used, and neither can your past income. You have to have some current income that is not what they call means tested. Means tested is where they look at your situation and say, based on your situation, we're going to give you some help. We're going to give you food stamps or housing assistance, whatever. That's mean tested. That money benefit can't be used, and in fact, you are really probably not going to get approved without a joint sponsor if you're on public benefits. That's our experience.
Okay, next question is from Abby Burhes. Can a person on a K-1 visa without EAD can operate business in Manila and get profit out of it? K-1 visa can operate. Well, I think it's something to do with the government in the Philippines, in Manila. Manila is in the Philippines, so if you want to operate business there, you have to at least comply with the Philippine government requirements doing
so
visa.
I haven't seen that one before, but I guess she's saying that she has apparently some kind of business that's running in the Philippines and now came on a K-1 and still wants to get that income. And the answer would be, sure, you're not, until you're a green card holder. Now, once you're a green card holder, or even when you got your EAD, once you start, well, we're not tax experts, but once you become a permanent resident, all of your income has to be reported and probably taxed by the U.S. government, no matter where it comes from, your worldwide income. Right now, you are just on a non-immigrant visa. It's almost like a tourist visa, except it allows you a pathway to immigration, the K-1 does. So while you're strictly on a K-1 visa, that would be, should be irrelevant. And again, we're not tax preparers. But at some point, once you get your green card, you are going to have to claim that income on your U.S. tax return. Okay, from Facebook, Mara asked, my fiance had her interview in April. We did the K-1, made over $58,000 last year. Can I file bankruptcy? 2 years ago, they denied him and said he would be a public charge because I filed bankruptcy. Can they really do that? Okay, let me look again. We had an interview in April. We did the K-1. I filed bankruptcy 2 years ago.
2 years ago.
Well, it shouldn't have mattered if you filed 2 years ago. If 2 years ago you filed, but last year you made $58,000, you should have been fine. So there may be something we're missing here. I mean, it's not, it's not like a credit application. It's just about what is the income that you're making. So, without understanding more about it, I mean, the bottom line, should they be able to deny? They, of course, can, deny anybody under any circumstance that they want, it almost seems like. But we've done lots of people with bankruptcies, I can tell you. Lots of people. Bankruptcies are pretty common. And we've done a lot of people with bankruptcy in their past, but now good income, and they always go through. I say always. So there must be something we're missing here. The income certainly, the $58,000 last year would certainly qualify you if you're still working right now. You're still working right now, you're still earning that level of income, you had a bankruptcy 2 years ago, you should be fine, but again, we'd have to have more details to know.
Next question is from Instagram. Okay. My friend was married to a U.S. citizen for 12 years, but the U.S. citizen passed away in 2011. They have 3 kids together, 3 citizen kids together. Can she still apply for a green card? Yeah, definitely, if the one of the kids is already of age, meaning 21 years of age, because if they're still minor children, they cannot file any petition for the mother. Yeah, they can file IR5 for the mom if they're already of age, which is 21 years.
Can she? They have 3 kids. Can she? So
Apply
I think they're asking about
card.
the mom.
The mom.
Can the mom apply for a green card? Oh.
Yeah. So the husband died 12 years ago. They have 3 citizen kids together.
They have 3 kids.
But if they're still minor, they could not apply
the
IR5.
kids. One of the kids would have to be 21 to petition you. You wouldn't be able to petition just based on the fact that
they are citizens.
That your kids are citizens and you married. Yeah, I mean, there might be something that a lawyer could help you with there. I don't know. That's outside of our expertise, but certainly you can't just simply go file for a visa. You're going to need a waiver or something. I don't even know for sure if it's possible. It's an odd situation. The one thing we do know you could definitely do is when one of these children reach 21, they could petition you. But now if you're already in the country out of status, then you're going to need a waiver and on and on and on. I would recommend an attorney on that one. Okay, from YouTube, Steve asked, for the CR1 visa, we've been married for 2 months, living together for 6 months in Vietnam. I'm 70, she's 36. Is that going to work? Well, it's certainly allowed. We do a lot of those. It's not uncommon. That's about a 34-year age difference. We see a lot of those. So while for the average person on the street, that might sound like a big gap, in our world, it's actually pretty common. So, the bottom line is proving you got a legitimate relationship. You've been together for a while. You've been living there. It sounds like a committed thing. I think you're going to be okay. You're certainly not going to be disqualified just based on that, I would say. And it's not really that uncommon. Not uncommon at all, really. Okay, that precludes our hour, or ends our hour for today. So we're going to wrap it up. We want to thank everybody for everybody who left comments, and please subscribe to us on YouTube to keep in touch with us and you can ask your questions also on our Facebook page if you have them. You don't necessarily have to wait for a video, although we love having people come to our videos. And so we said we're going to give away $100 credit, and we did, and that person is Robert Locke. So Robert Locke, we got your name here. When you call, we will take care of that. You don't have to use it today. It could be whenever, sometime in the future, but we'll have that in our records. It's been a great session. We've had a lot of good questions today. We want to thank everybody for coming and joining us today, and we hope you'll come back and see us again on our next live RapidVisa Live from Las Vegas broadcast. Thank you.
Thank you.
Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. RapidVisa is a document preparation firm licensed and bonded in the state of Nevada. If you need help with your immigration petition, check us out. We've helped over 30,000 customers from 180 countries apply successfully. Check out our testimonial library at RapidVisa.com, where we have over 1,000 photo testimonials from actual customers describing their immigration journey with RapidVisa. There's no cost or obligation to create your RapidVisa account. You can create your free account at RapidVisa.com/free. Be sure to like and follow us on Facebook to be notified of future live streams. Thank you, and see you next time.